Did all 9 register?
We're missing 2, Eric Jones and number 5.
Okay. It's 9:10. All right, I'm going to call this hearing to order. I'm calling to order this hearing. This is a public hearing of the Committee of the Whole. I am Phil Mendelson, Chair of the Committee of the Whole and Chair of the Council of the District of Columbia. Today is Wednesday, November 4th, 2020. The time is 9:10 in the morning. This hearing is being conducted virtually. That means it is being conducted live via the Zoom video conference broadcast platform and also being broadcast over Council Channel, cable TV channel 13. And it is also available on the DC Council website, which is www.dccouncil.us. The subject of this morning's hearing is Bill 23-965, entitled the Displaced Workers' Right to Reinstatement and Retention Amendment Act of 2020. This legislation was introduced by me on October 5th, 2020. And the stated purpose of this legislation, and I'm reading from the hearing notice, is to amend the Displaced Workers Protection Act of 1994 to ensure that eligible employees who have been displaced by COVID-19 have the opportunity to be reinstated once their employer reopens after the current global pandemic. Industries such as the hotel industry have been significantly impacted by the COVID-19 pandemic, leaving many of their employees without jobs for the foreseeable future. While these employees are unionized, their collective bargaining agreement only provides for an 18-month callback period from when their hotels closed, which for most of the hotels was March or April of this year. Given that many hotels are not set to reopen until the pandemic subsides, which could well be into 2021, and given that it is predicted that it will take until mid-2022 before the hotel industry largely recovers and is back to near capacity, the 18-month callback will have ended, leaving many eligible employees without any job reinstatement or retention protection. As written, the Bill 23-965, is broader than just the hotel industry. The bill seeks to rectify this issue with regard to these displaced workers. Now, the record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on November 18th, 2020. So the notice of this hearing was given well within the 15-day time requirement, and the record will be open for 2 weeks. But it is my hope that we'll be able to move forward with this legislation, reflecting the testimony we received today before the end of Council Period 23. With that, let me turn to my colleague, Councilmember Alyssa Silverman, if you have any opening remarks.
Yes, good morning, Chairman Mendelson, and good morning to everyone. I'm sure it is a groggy morning for many of us, and as we await all the votes being counted in our city and across the country. But even with a very active day and evening last night, I wanted to be here to express my support for this bill, which was retained in the Committee of the Whole. As Labor Chair, I am very concerned about how we will recover from COVID. It is often said this is an unprecedented public health emergency and recession. In that, a lot of our industries that we rely on in the city for work are very much tied to the hospitality industry, to travel, to our convention industry, all of which have been devastated by the necessary measures that we've taken to protect public health, but means that, as you said in your opening statement, Mr. Chairman, jobs in the hotel industry, related convention industry, and hospitality industry will not come back fully until there is a vaccine and there's confidence that we can congregate and travel safely without risking our health. And this bill addresses that, in that I don't think any collective bargaining agreement could have foreseen the COVID recession, and that industries would be closed for such a long period of time, which might necessitate change of ownership, but that workers will come back to those industries, and we want to make sure that those workers have protections and job protection when these industries are able to return. So I want to thank you for holding this hearing, Mr. Chairman. I do look forward to the testimony ahead and look forward to supporting this bill. Thank you.
Thank you, Councilmember Silverman. It is the nature of our hearings that we are time limited, and this hearing has to end by 11 o'clock. We have 9 folks who signed up. I'm told that only 7 of them actually registered. I'm going to call everybody into the room, so to speak, so that they can we can recognize each one for their testimony, and then we will have at least one round of questions. So Nico Belitza, who's an organizer with DC Jobs with Justice; Eric Jones, who's Vice President of Government Affairs for AOBA, and I'm told he may not be here; Tracy Javier, who is a member of Unite HCRE Local 25; Nels Ellsworth, who's also a member of Unite HCRE Local 25; Clayton Sinyai, who's Executive Director of Catholic Labor Network, but I'm told that he may not be here; Devki Verk, who's outside counsel to Unite HCRE Local 25; John Boardman, who's Executive Secretary Treasurer for Unite HCRE Local 25; Juan Bellman, who is listed as a public witness; and Gregory Allen, who's listed as a public witness. So I'm going to call folks to testify in order. I think the witness list said 4 minutes. In any event, I will give folks 4 minutes. And well, I'm not seeing it quickly. I'll give everybody 4 minutes. We'll see how that goes. And with that, Nico Belitza.
Hi.
Good morning.
Good morning. All right. Chairperson Mendelson, members of the committee, thank you for the opportunity to testify. My name is Nico Belitza, and I'm an organizer with DC Jobs with Justice. DCJ with J is a 70+ member coalition made up of labor organizations, community groups, faith-based organizations, and student groups. Together, we're dedicated to protecting and advancing the rights of working people and supporting community struggle. I'm here today to express our strong support for the Displaced Workers Right to Reinstatement and Retention Amendment Act of 2020. The COVID-19 induced recession has erased nearly 7 years of private sector job growth in the district, eliminating more than 57,000 jobs. Although the hospitality sector has been the hardest hit by COVID, other sectors have also seen large-scale layoffs. Employees in administrative and support industries have lost 11,000 jobs. Construction and building trades have also been impacted by COVID-induced job losses. A survey conducted by the Associated General Contractors of America found that 30% of contractors had furloughed or terminated jobs. One component of an effective cross-sector response to this crisis is ensuring that the many district workers laid off over the past few months are given the opportunity to return to their original positions. Beyond ensuring that workers would have more security and certainty about their job, a right to reinstatement would ensure that all workers would be able to participate in that recovery. Employers often use recessions and the availability of a large labor pool to pay less to new workers. By ensuring that workers are able to resume their pre-pandemic role, this bill would protect the wages that allow workers to survive in an increasingly unaffordable city. Furthermore, Black workers have been disproportionately impacted by the pandemic-induced job losses and would be greatly helped by a right to recovery. A Washington Post Ipsos poll in May of this year found that 16% of Black workers reported having been laid off or furloughed since the pandemic. A right to reinstatement would help protect the jobs of Black Washingtonians. Protecting workers is critical to our recovery and the long-term economic security of DC residents. I urge the council to vote yes on this legislation and demonstrate a commitment to workers who have already built a career in DC. Thank you, Chairman Mendelson, for your leadership on this important issue, and we look forward to working with you to pass this bill.
Thank you. And I don't have a copy of your statement. Have you submitted it?
I don't think I have. I can email that over.
Would you please, if you email it over now, I might be able to get it in time to read it before I'm more visual than audio. I probably shouldn't say that at a hearing because you all are speaking, but it helps for me to see the testimony. I don't believe Eric Jones is with us. Tracy Javier? And
Yes, hi. Sorry. Good morning, Chairman Mendelson, Councilman Member Silverman. I know we are probably at our limits of stress, especially after yesterday, but I still hope to find you all in as good a spirits as we all can muster today. My name is Tracy Javier, and I have been a bartender at the W Hotel, working at POV, their premier rooftop lounge, for the past 10 years. The union has helped me maintain a living wage and secured me with benefits when we've been laid off. With a living wage, we are secured in competitive wages for an expensive city. With inflation in the economy always bringing the cost of living to the sky, the union fights to ensure our wages reflect our surroundings. I wouldn't stand a fighting chance to be able to live where I do in DC without the help to negotiate competitive living wages. 2020 has been a difficult year for us in the hospitality industry. My hotel, as recently as the end of September, started bringing back minimal staff to open our restaurants. My outlet is running at less than 25% of our normal operating hours and staffing levels. Healthcare has been cut to those who have been laid off for the 6+ months of this pandemic, and I am one of the few lucky ones who have been able to hold on to it due to the fact that I have worked just 3 shifts in barely over a month. The union helped negotiate securing health insurance from March until October, but now a lot of us have to readjust. Readjusting and shifting is not only crucial to provide for our families and ourselves, but also a must in accordance with the ever-changing information of this deadly virus. It is stressful with no end in sight, and if a vaccine happens soon, it's still months, but realistically some years before we can even look to a brighter horizon. I worry that if things take a turn for the worse, I could be out of this job permanently. Those who have held on to the hope of coming back to their hotel once it is safe to do so should not have the hope snuffed out from under them because of the severity of this virus and the duration of the layoffs. We all have experienced the loss, whether it is with loved ones, the economy, our jobs, and the sense of normalcy. The union is fighting for us to at least make sure our jobs are available to go back to once we can resume a safe new normal life. Lately, I've been thinking about the 5 human truths I learned when first joining the W team: to belong, to feel special, to reach my potential, to be in control, and to be understood. COVID-19 has tested us as humans on these values. How can one seek these 5 truths while put under the economic, financial, health, and personal pressure? I hope with me speaking to you all today is that you help us to stay in these truths and with the safety of our jobs and with the help of Local 25. Thank you for your time and your humanity.
Thank you, Ms. Javier. And thank you for giving us a copy of your statement ahead of time. Nels Ellsworth? Do I see Nels Ellsworth? Yes.
Good morning. Good morning, Chairman
Nels,
Mendelson.
is your
I'm
name,
here.
is your first name
Yes.
Nels or Nedra?
Nedra.
Okay. Please proceed.
Okay. Good morning, Chairman Mendelson, and thank you for holding this hearing today. My name is Nedra Ellsworth, and I'm a housekeeper at the Marriott Wortman Park Hotel. I am also a member of Local 25 and a DC resident. I want to talk about why my union job is so important and why the recall bill will make sure it does not disappear. My job guarantees me things I could never dream of if I didn't have a union contract, like regular wages and vacation pay. I have a pension, so I will be able to retire one day. My employer pays all of our healthcare costs when we are working, including dental and for an eye doctor. There are no non-union jobs in the city that even come close. But just as importantly, this job means I have power in my workplace. I once had a guest check out late who left me a tip. My manager went into the room before I had the chance to clean it and pocketed the tip for himself. Working with a union rep, I was able to go to HR without fear of being punished by management. And that manager was reassigned to another building. This never would have happened without our contract. But we are scared that our hotel owners are going to use the pandemic as an excuse to get rid of union jobs. I can't afford that. I'm a grandmother and a great grandmother. I have a lot of family members who depend on me. If I lose this job, I cannot provide things for my grandchildren or great grandchildren, which is especially painful to think about with the holidays around the corner. I hope you can move this bill forward and work with our union to make sure it protects my job. Thank you very much for your time.
Thank you, Ms. Ellsworth. Clayton Sinai, I believe that he is not here. Dev Keyverk.
Good morning, Mr. Chairman. I'm Dave Keyverk, outside counsel for Local 25. I believe that I'm here and available to answer questions by the council members. But before I do that, I could just make two quick points about the legislation. There's been a lot of discussion about the hospitality industry and the hotel industry in particular, and that has obviously been one of the hardest hit industries in the district during the COVID-19 pandemic. But the bill as written applies to all workers, union and non-union, in all industries, at least as I understand the bill. As I think is plain, is intended to ensure a minimal level of job security and protection for all affected workers following the pandemic. And the breadth of the bill is important, obviously, not only for purposes of assisting the broadest number of people who have been devastated by the economic catastrophe that has followed and is continuing as a result of COVID-19, but is also important in terms of sustaining the bill against any potential challenge under the standards of what they call federal preemption, which provides us a level of balance between what states are allowed to regulate and what the federal government is allowed to regulate. And states in general have broad power to regulate economic standards broadly for all of their citizens and affected workers, and in particular to provide minimum protections for all workers, regardless of whether they are covered by a collective bargaining agreement or not, regardless of which industry they are in. That I think is particularly important, given that so much of the testimony, at least so far, has been focused on a particular industry. The breadth of the bill is something that will move the district forward for all of its workers and provide those protections for all. I'm available to answer questions if they should come up. Thank you for your time.
Thank you. John.
Did you call on me, Mr. Chairman?
I did. I call on you
Okay.
frequently. Actually, I've only called on you once in this hearing, but it's your turn.
Good morning, Mr. Chairman and Councilmember Silverman. It's a pleasure to be here with you this morning on this important issue, and I'd be remiss if I didn't thank Tracy and Nedra for sharing their stories this morning. I am John Boardman, Executive Secretary Treasurer of Unite Here Local 25. We are a hospitality Workers' unions of more than 7,000 members serving the National Capital Region. As you know, COVID-19 has had a significant impact on employment generally and the service sector specifically. For the hospitality industry, it has been devastating, with the crushing effects on employment expected to extend through 2021. In our union, 90% of our members remain out of work. They need your support for legislative protections that will allow them to return to their jobs once that work is again available. We are asking for your support for a very simple concept: that a worker who is thrown out of work through no fault of their own has a guaranteed right to return to his or her job when that job comes back. It would seem simple, but there are those who wish to use this pandemic, this human tragedy, to gain advantage. A global pandemic is not something that we could have anticipated when we negotiated our contracts, nor is it something most workplaces have built into their policies. That is why we are asking that you prevent further harm from befalling district workers. There are some that will claim that this puts businesses at a disadvantage. How? How is it returning a skilled, experienced worker to the job they previously held a disadvantage? The legislation will not require that every worker be returned to work on a date certain. It will, however, give workers the enforceable right to his or her job when it exists again. Don't fall for the specious arguments of people with nefarious intent. Workers have endured enough. You can relieve some of the stress as they are waiting for the economy to restart. Let them know they have their job and that they can go back to work. I have taken the liberty of attaching some draft amendments to the proposed legislation, which we believe further clarifies the rights I have just noted above. We look forward to working with all of you to make this simple concept a reality. Thank you for your time, and I am happy to answer any questions.
Thank you, Mr. Boardman. Juan Bellman.
Hello and good morning, council members. My name is Juan Luis Berman Guerrero, and I work at Georgetown University's Commonwealth Initiative for Labor and the Working Poor.
I can hardly hear you. Can you?
Can you hear me better this way?
Totally.
Wonderful. I'll start over. Hello and good morning, council members. My name is Juan Luis Berman Guerrero, and I work at Georgetown University's Commonwealth Initiative for Labor and the Working Poor. I myself am a DACA recipient, and as an immigrant, I know that there are very few safety nets that protect our immigrant community. I am here to speak on the importance of passing the Displaced Workers Rights to Reinstatement and Retention Amendment Act of 2020. As you all have seen, our community is suffering greatly. It is heartbreaking to hear where two working parents lost their jobs and are now scrambling to figure out how to even have enough food on their table. Our community members want and need their jobs back, not only in hotels and restaurants, but in construction, retail, cleaning, and a multitude of different fields. We need to make sure that when businesses have the opportunity to hire employees back, that they prioritize those members that were working there before and are part of our community. Not to think that bringing employees who already know the job will speed the economic recovery by not investing in retraining. Let's invest in DC, in our community, and in the hard workers that make DC a great city in which to live and work. I conclude by urging the council to pass the Displaced Workers' Rights to Reinstatement and Retention Amendment Act of 2020. Thank you for your time, and I hope you have a wonderful day.
Thank you, Mr. Bellman. And I don't have a copy of your statement, so if you could provide that. Gregory Allen.
Hello, excuse me. Hello, and thank you for having me here, council members. Good morning. My name is Gregory Allen, and I'm a hospitality professional of 13 years, and I live in Ward 1. I'm here to testify in support of the Displaced Workers Right to Reinstatement and Retention Amendment Act. I, along with thousands of restaurant workers across DC, were laid off back in March. Even though restaurants have been reopening for the past several months, they're only open at limited capacity, leaving so many of us still out of work. Additionally, I've seen so many restaurants lay off their employees and then hire a brand new staff, giving long-term employees no chance to return to their old positions. Former employees should always be given first choice to return, which is why I'm in support of this bill. I would also like to read a statement written by a colleague of mine who was directly impacted by this situation as well. My name is Nicola, and I'm a restaurant worker and Ward 4 resident. Before COVID-19, I worked for the same restaurant for 6 years. Around mid-March, we all got furloughed due to the pandemic. Once the restaurants started reopening, many people, including myself, hoped that we were going to be called back to work. Only a handful of previous employees were called to come back. The rest of the people were newly hired. While I was looking for another job, I saw online that my restaurant was looking for new employees for all positions, including mine. Many people are experiencing the same situation, and many of them have families to feed. I think that many restaurants are abusing this situation and using this opportunity to reset their restaurant policies in favor of their company and lower the hourly wage for new employees, therefore having less expenses. We're not just numbers with dollar signs. We're human beings that have families to support, and we believe that hard work should be appreciated, which is why you need to pass this legislation. Thank you for your time.
Thank you, Mr. Allen. And I do have a copy of your statement, so thank you for that. All right, so to put us on 10-minute clock, excuse me, and probably we'll have a couple rounds. I just kind of wanted to start by getting a little bit more of a sense of what's going on. Let me see. Javier, you work at the Hotel W, and Ms. Ellsworth, you work at the Marriott Wardman Park. Kind of wanted to ask each of you what the work situation is like in those hotels. You both are currently working, so you were able to maintain employment, but are you working the same number of hours, Ms. Javier?
I'm not. I only worked 3 shifts, so I think that's, I'm really bad at math, 24 hours in the last month.
Now, are you still getting the same benefits, or are those at risk?
The benefits are, like, once we start working again, I think we have 4 months of health benefits. So, but if I don't work for another 4 months, then my benefits are taken away. I think that's what it is. I'm sorry if I misspoke on that.
Yeah. But now, what about the rest of the hotel? Substantial number of the staff are right now out of work?
Yes, probably about maybe 75%. I want to say if staff is laid off of the whole hotel.
Yeah. And so you don't know when you'll be working again, as in, so they've been calling you back part-time, but it's
not. So for my position, bartending, there's only 1 bartender that gets to work 3 shifts a week, 1 bartender that gets to work 2 shifts a week, and then I'm the 3rd bartender per seniority. So whenever one of those have PTO or call out, then I would be called. So I'm like an alternate in a way. So.
Which creates a lot of uncertainty for you.
Yes.
And Ms. Ellsworth, you're at Marriott Wardman Park.
Yes.
What's the situation there?
I have been laid off.
Turn on your camera.
Oh, okay. I have been laid off of my job since March.
Are there many workers working there these days, or?
Currently there are no union employees working at the hotel. The hotel is actually closed.
All right, so it's closed.
Because of the pandemic, it's closed.
Yeah. And so your benefits have run out?
Yes, they have. And I have been employed there for 27 years.
And you have no sense of when they might reopen?
No, I do not.
That's rough. Sorry about that. Mr. Allen, you work, your testimony is that you've worked in my impression is in the restaurant business?
Yes, I've been in the restaurant industry for 13 years now.
And,
I'm sorry.
Oh, go on. Currently,
I was last hired to work at Sequoia in March, and I was furloughed as soon as I was hired in March. I recently found out on the website that they have reopened. They just haven't contacted me.
and at the point that they furloughed you, you didn't have any, you were no longer getting any benefits like health insurance. Is that correct?
No, I wasn't getting anything. I was actually a new hire, so I wouldn't have even been eligible for benefits at the point.
Yeah. So thank you. I want to thank each of you for your testimony. I'm going to turn to Mr. Boardman, and that may involve Ms. Verk. So there seems to be, when I first looked at introducing this legislation, I thought of it as being narrowly tailored to the hospitality sector, hotels and restaurants, because those are the two lines of business that have been most severely impacted. The legislation as drafted is broader, and Ms. Verk kind of touched on that. Why is that necessary? Mr. Boardman?
Well, it's necessary in order to sustain the legislation from an attack on the theory of federal preemption. And with that, Mr. Chairman, if you have no objection, I'll hand it off to Ms. Verk, who will give you sort of the technical components of what federal preemption is, but in particular, why having a broad-based approach handles two problems. One, addresses federal preemption, but also recognizes that while the service sector, and in particular hospitality, have been devastated, there are issues. The issue of returning to work is not limited to the hospitality industry. There are a number of different sectors within the service sector that are affected by the pandemic. And so it makes sense, in our opinion, from both a being legally sufficient, but also from the standpoint of protecting all workers from the same sort of problem of not being able to return to a job they had before. And I'll turn it over to Devki if you want to get more on the federal preemption issue.
Oh, well, I think this is probably one of the more important issues around this bill. Ms. Verk?
Yes, thank you, Mr. Chairman. Let me just start out by saying, and be clear about it, that I do not believe that having legislation that is aimed or targeted at one or more sectors necessarily deals that piece of legislation a fatal blow under federal preemption standards. I don't mean to say that at all. State and local legislatures are capable and have authority to exercise their police powers to govern and set minimum standards for the employment relationship, and to do that in a way that protects the most or protects the areas or sectors that they believe are most affected. So let me just start with that. So your question is it necessary? I don't know that it is necessary to have the bill aimed at all workers in order for it to be upheld. But I do think that, at least under current federal preemption standards, state and local legislation is on the strongest ground when a legislature is setting minimum standards in the labor area that apply to all workers across a broad set of industries. Where legislation has sometimes foundered is when it appears to apply only to a particular set of workers, or to put a thumb on the scales in favor of or against collectively bargained terms, or in favor of one party to a collective bargaining agreement or another. That is where the conflict that the preemption principles discuss, the conflict between the federal right to legislate in a particular area and a state right to legislate in a particular area. Where those two come into conflict is when the state or local legislation conflicts with federal principles or a federal legislative scheme. So the broader based the legislation, the less likely it is to be found by the courts to be essentially a bill aimed and targeted only at labor or unionized, the concerns of unionized workers, or to deal with issues that are by federal principles left exclusively to the parties to resolve. So that was the tenor of my earlier comment. I don't believe it is necessary, but I believe it puts the bill on stronger ground to have it as drafted and applied across all industries. Does that help to answer your question?
Yeah, yes. The bill picks up on existing law. We have a Displaced Workers Act. And that Displaced Workers Act, if I remember correctly, was first adopted in the 1990s, and it was expanded about 15 years ago. And it applies to 2 or 3 very specific sectors. Parking attendants, I know, is one. And
right.
And my understanding is that law has been taken to court, and it was upheld by the circuit court. So
it was, and that is exactly why I said I don't know that it is necessary to have this law apply to all workers who have been affected by the pandemic. But again, the legislation, at least under current preemption doctrine, is on stronger ground the more broader based it is. The cases that, yeah, go ahead. I'm sorry.
So then this may be more of a policy issue than a legal issue, in that do we want to help hotel workers? And actually, if we're going to help hotel workers, why don't we help all workers who've been displaced by the pandemic? And that's what I mean by policy, as opposed to legal, which is, gosh, we've got to just do this across the board for legal reasons.
Right. That's exactly correct. That is exactly correct.
And I'm out of time. I'm going to turn to Councilmember Silverman, and then I'll come back. And actually, we were Clayton Sinyai has come into the room late, or has joined us late. We're going to let him in the room after you, Councilmember Silverman. I'll recognize him to testify, and then we'll go back to questions. Councilmember Silverman.
Thank you very much, Mr. Chairman. First, let me say to Ms. Ellsworth and Mr. Allen, who testified, I certainly want to say I know it's a very hard time for both of you. Mr. Allen, you have testified at both of my unemployment oversight hearings, and we have been working with you. I do have some questions about the bill, and it specifically goes to the conversation that we just had. So Ms. Burke, you made the point that the bill doesn't just apply to workers with a collective bargaining agreement, but broadly applies to workers in our city. So help me understand, for a restaurant employee like Mr. Allen, for example, who's not covered under a collective bargaining agreement, how does this bill help him?
As I understand it, Councilmember Silverman, what the bill does is say that if there is a job, if Mr. Allen's job comes back, Mr. Allen has to be reinstated to that job. They cannot hire somebody off the street for that job. That's the first way in which it helps him. As Mr. Boardman testified, the notion here under this bill, as it is under the existing Displaced Worker Protection Act, is that if a worker's job exists, the worker ought to be the one to fill it. And as I understand from Mr. Allen's testimony, that's not what has happened in many instances. And instead, employers have essentially been using the pandemic as a way to either find new workers or otherwise, reset their employment, and that under the bill would not be permissible.
Mr. Boardman, do you share Ms. Burke's interpretation of the bill?
I do, and I do want to follow up on something the chairman said. There are two components here. One is the issue of satisfying as best we can the contents of the bill with respect to legal issues. What we are really talking about now, and I think the chairman framed it appropriately, is there is a moral issue to, in our opinion, that goes beyond just helping one industry or another. We think any worker, whether they happen to be in the hospitality industry, clean a building, work in the construction area, any of those individuals who had a job ought to be able to go back to it if the job exists. We're not requiring employers to put people back to work when there is no work, but if there is work, Tracy or Nedra or Gregory ought to be able to return to the job that they had, regardless of how long they have been laid off. And that ought to be, doesn't matter what industry you're in. We have heard from hospitality workers here this morning, but it really ought to be extended beyond just the sector that has been most devastated. Every worker that's lost their job and wants to go back to work should have that insured right.
Okay. So I understand. Certainly, I think we all share the moral imperative, which is we want all of our workers to have good paying jobs and benefits. And certainly this has been a devastating time for a lot of our workers. I think it cannot be lost that there are 150,000 district workers who are currently on unemployment. For example, we talk about the hospitality industry, but for hotels without a collective bargaining agreement, how would this legislation change current practices?
Well, I think it has one incredibly important feature, and that is the right to go back to the job that you held before.
Okay.
It's that simple. And to the extent that there are two people who might have had the job before, there is a system in the proposed amendments, which I've sent in, which sorts that out on a rational basis of the individual who has worked longest at that place of employment in that classification should be the one that returns first. So we've tried to anticipate both the return to work and have that ramp up as the business ramps up. But to the extent that there is a group of individuals that qualify as having been previously employed in a position that's opened up, our proposed amendment says that that should be sorted out by seniority.
Okay. So, Mr. Boardman, in a union workplace, I think seniority records on seniority are kept fairly well. How would that work in a environment that is not under a collective bargaining agreement?
I think there are, as a practical matter, there are a variety of different ways that you can look at determining whether I've worked someplace before you.
Okay.
All employers are required to keep payroll records. Payroll records would indicate when somebody first is employed. Theoretically, if there are two people, you can determine if there's an issue. But I bet if you talk to Mr. Allen or Tracy or Nedra, they would be able to tell you point blank who's higher on the seniority list in their workplaces. That's just the nature of going to work in our industry and every other industry. But if there was a dispute, there are records that one can rely on that demonstrate when somebody started work.
Sure. Well, the reason I asked Mr. Boardman is as labor chair, I have spent a lot of time with workers who have lost income and employment, and especially in the hospitality industry and in the restaurant industry. And one of the challenges of figuring out their claims is that they work in a lot of different places. You know, a lot of people who are in the restaurant industry, for example, work in multiple workplaces and might seasonally work. So, you know, you're working a lot of hours here at one time and not a lot of hours at other times. I just use that as a contrast to where you might have a more stable job where it's very clear what the position is. I think I'm maybe not articulating my point, but I feel like in other parts of the hospitality industry that's been really devastated by COVID, the workplace is more fluid. And I'm just concerned about how we would determine whether seniority might be the best determination of how to protect workers.
Well, as someone who has dealt with this issue virtually every day for 40 years, I can tell you that the only impartial methodology for determining this kind of sequencing is seniority. There's no other impartial system.
Okay. How will we enforce this bill?
There are a couple of provisions in there, but I think in all likelihood, we believe that the third-party enforcement provisions are the most helpful in this situation. It will allow agencies and independent help to workers who have not been put back to work in the right order.
Right. So certainly Local 25, I'm sure, will do an excellent job of representing its workers. But what about workers, as we said, if the bill is more broad? So what is a worker who's not represented by a union? How will they seek enforcement of this bill? How will they be able to go to their employer and say, I have the most seniority and I should be reinstated?
Well, it's certainly not as cut and dry without a union contract and without the enforcement that a union brings, but it would certainly, there is nothing that prevents unions like Local 25 or any other institution who advocates on behalf of working men and women to pursue or to assist in pursuing the rights that would be enumerated under this legislation. It also is certainly anticipated that the District of Columbia can play a role in making sure that those rights are enforced as well. But we all know, Council Member, that in the current state of affairs, the more eyes that you have looking at a problem, the more institutions that have a legal ability to help workers like the ones you've heard today, the more likely it is that the intent and good policy that's enumerated in this legislation will be enforced. So we think that the construct that is proposed will help all of those who want to have their rights protected, and so they can go back to work when their work starts again.
Thank you, Mr. Boardman. Yes, the bill was not referred to the Labor Committee, so I am asking some more basic questions just to get a handle on how the bill would work. I just want to reiterate that, you know, this has been a devastating pandemic for workers in particular industries in our city. And I think we want to make sure that those workers have a fair chance to be able to return to the work that they have done and helped our city with for years. I may have left out Ms. Javier. It's because I don't see everyone on my screen. But if you've been working obviously for 27 years in a job and are losing employment through no fault of your own, you should be able to have the ability to return to that work if that job is available and be able to hang on to those benefits. I think I'm out of time. If the clock is correct, Mr. Chairman, you're usually such a vigilant clock watcher of mine. So thank you for the extra time. I'm going to listen in on your next round of questions, and I might have a few more of my own.
Sure, Councilmember. Yeah, I had my camera off. I wanted to see how long you would go without my interrupting you. So glad you caught yourself at 3 minutes over. Let me follow up on the enforcement issue. Just a moment. I'm just was reminded, I had said that Clayton Sinyai could testify. So if he's in, and then I'll start my second round of questions, which will be on enforcement. Mr. Sinyai.
Thank you, Chairman. I apologize. I was struggling with the technology earlier and missed my time. I was watching with great interest, however. I appreciate your giving me the chance to say a few words. I'm the Executive Director of the Catholic Labor Network based at Georgetown University, and I came out today to urge the Council to support the Displaced Workers' Right to Reinstatement and Retention Amendment Act of 2020. We have just been through a terrible year that brought illness and suffering to millions of Americans. Many were touched directly when they contracted the novel coronavirus, but many others faced sudden and intense financial hardship when their employer closed or drastically reduced operations in the face of the deadly pandemic. We do not hold firms compelled by COVID-19 to shut their doors responsible for this hardship. However, as our hotels, restaurants, shops, and offices have reopened, some employers have sought to exploit today's difficult labor market to dismiss their career employees and hire replacement workers at reduced wages and benefits. This promises to prolong the economic crisis by lowering wages of local workers across the board. Worse still, it is profoundly unjust. My organization, the Catholic Labor Network, is an association of lay Catholics, clergy, and religious motivated by a shared commitment to Catholic social teaching on worker justice. As such, we believe that every successful business is the result of a partnership between management and labor. Justice requires that the firms entering recovery offer employment first to the career employees whose labor built these businesses. For these reasons, we urge the members of the Council to vote yes on the Displaced Workers' Right to Reinstatement and Retention Amendment Act of 2020. Thank you very much.
Thank you, Mr. Sinyai. I wanted to follow up on where Councilmember Silverman left off, which had to do with enforcement. So as I understand it, the bill that was introduced didn't make any changes to, I think it's section 32-103 of the code, which is the enforcement section. But now you are, and then when I say you, I'm looking at Mr. Boardman, talking about some changes there. Can you explain why? What and why?
Well, even under the current legislation, Mr. Chairman, there is permissible third-party enforcement. But we feel that is a critically important part of this piece or this effort. For exactly the reasons I enumerated a moment ago. If I'm not to denigrate the ability of the District of Columbia to enforce its own laws, that is not the intent here. The intent is to simply say a helping hand across a broad section of interested institutions certainly can't hurt in assisting in the enforcement of both the letter of the law and also the intent. So we're trying to be realists here, Mr. Chairman. And I think all of us know that as the recovery, and let us hope that it comes sooner rather than later, but as this recovery rolls forward, it is entirely possible that there are going to be a number of people like Mr. Allen in a variety of different industries, not just hospitality, but certainly in hospitality, that are going to need the provisions of this law to protect their access to the job they previously held. The more enforcement ability that we have, either district or private sector institutions, the better off these workers are likely to be in terms of pursuing the rights that they have under the bill.
So the issue has to do with third-party enforcement?
Yes, we believe that third-party enforcement is a critical component of these types of policy decisions. If you simply leave it up to the District of Columbia, and again, my intent here is not to degrade the ability of the district's government or its employees to carry out the mission, but I think we're all savvy enough to recognize that the more eyes you have on a situation, the more likely it is that it will go according to what the policy prescribes. Fewer eyes means fewer people watching, and the likelihood of circumventing the intent and the requirement of the law increases. So why not start out by saying we're going to get as many eyes on these situations as possible, and hopefully every employer will do the right thing. But if they don't, then the opportunity to encourage them to do the right thing is there, not only through the district, but through third-party enforcement.
All right, I wanted to ask you about as well, definition of employer. So you're asking for a broader definition of employer. I'm not sure, I'm looking at notes here. I'm not sure if that's in your revisions or the bill is introduced as broader than the current law.
We actually, Mr. Chairman, have in the proposal for amendments attached to my testimony, left in essence, the current law in place, which deals with a specific situation. The current code on displaced workers deals largely with contractors and employment related to contractors. Our proposal is that there would be a separate amended part of the legislation that broadens it out beyond just the currently anticipated coverage of employees of contractors and deals with employment situations across the board. That would certainly capture the sector that we're talking about here, which is hospitality, but it also gets all the other sectors that are affected by the economic fallout from the pandemic. So we have not replaced the definition of covered employee that exists in the current law. We have introduced a new definition which specifically applies to the situations that result from the pandemic. And that goes both from employee side and the employer side. There are two new definitions of both those entities.
Well, I want to pursue employer a little bit because I have in the back of my head that there's a concern that there are different ways that employers can structure themselves. So you're reminding me that the current statute, the existing law, Displaced Workers Act, does speak to contractors, and when they contracts like at a parking garage, the owner of the garage contracts with the company to run the garage, changes that contract. That's what the Displaced Workers speaks to. Displaced Workers Act speaks to. That's the current law. This is to get at, for example, hotels, and I will just acknowledge again that this bill is broader than just hotels. So a hotel is not a contractor, so I get that. But is there a concern over, is there a concern over ownership structure? And that's part of what you're looking at with the definition of employer?
I think you've put your finger on it there, Mr. Chairman. Is speaking about the hospitality industry in particular, but also some of the same characteristics are now present in a much broader context. In hospitality, hotels in particular, we anticipate that there is going to be a huge round of disruption in ownership and operators. The distinction being ownership are the people that control the asset, the bricks and mortar, and operators are those that run the business of that asset. So for example, you could have XYZ private equity fund own a Marriott hotel, and Marriott or some other operator could be the one that is operating in that hotel and could be and would be the employer. Two things can happen. You can have an owner default, for example, and we anticipate that there is going to be a good deal of that. Or you could have an owner that sells out because they cannot make payment. And we should all be aware that there's currently about 175 billion with a B of dry powder, purchasing power to go into the hotel industry to purchase assets. And why is that important? Well, our definition of employer anticipates that those changes are likely to take place and says, regardless of how that ownership or who operates that asset, if they are acting in substantially the same business, if there's still a hotel or there's still a restaurant, then whoever is operating it, stepping in the place of the previous owner or the previous operator, they have the same obligation to the employee. That if that job exists that the worker held before, that they be allowed to return to their job.
That doesn't speak to the definition of employer. That speaks to ensuring that this responsibility applies not only to the owner, but successors.
Yes, that's correct.
And what I was getting at was whether there's an issue over the definition of employer, that there's some way of a business restructuring itself so somehow it wouldn't be defined as or come under the definition of employer. But I'm not hearing that that's the concern. It's more the successors. It's today's owner as well as if it goes into bankruptcy or is bought out, tomorrow's owner.
And in the case of hospitality, it may not only be the owner, Mr. Chairman, it may also be the company that's operating the property, who in fact acts as the employer. But you've put your finger on the term of art. The term of art is successorship. Can we, as these businesses, reconfigure themselves? And there's no way, and I wish I could tell you after 40 years of doing this that I had some way to predict all the different schemes that people construct to create LLCs and shells within shells within shells. I don't think any of us can anticipate what those constructs might be. Our proposed language says we follow all the way through. And if at the end of the day, the business ends up in substantially the same business, if it's still a hotel, if it's still a restaurant, if it's still an office building, that whoever's owning it, whoever is running it, has an obligation to fill the jobs that make that business run from the pool of employees that had them before. So successorship absolutely is the appropriate term. And we believe that the language that we proposed takes care of all those situations that might arise without trying to go through what would be an impossible task of trying to enumerate every single one of those situations by name and by definition. It's not possible.
Let me ask you this, and I realize I'm over my time, but I'll let Councilmember Silverman go over as well. So the bill applies, as I understand it, to retail as well, or at least the change amendments you seek to the bill apply to retail as well. So let's say Brooks Brothers, which I believe is filed for bankruptcy. Now they may come out of it, but let's just say that for purposes of example, Brooks Brothers is bought out by Old Navy. And the Brooks Brothers store that was at the corner of the street is now an Old Navy store. Different. Do you think that, is it your intent that the provisions of this bill would apply?
It is our intent, Mr. Chairman, but as you look at the amendments that we've proposed, there, for that kind of change, there would be a review period that would be allowed the new employer 90 days to look at the employee once they get on the job. So we've anticipated that kind of change, although I think Brooks Brothers would be deeply distressed if they were taken over by Old Navy. But if
that's why I gave that example, because it's a very different.
If that happened, Mr. Chairman, you are correct in your assumption that the successorship provision would apply. Employees who were previously employed at Brooks Brothers would have a shot at Old Navy, and they would be looked at from the standpoint of the new employer for a period of 90 days and would have the protection of the law that allows them to get into the job, prove themselves, see if they like it, and allows the employer to look at the new employee.
Councilmember Silverman, did you have more questions?
Yes, I do, Mr. Chairman. I actually want to pursue the line of questioning a little bit more that you just engaged in. So I think this question is either to Mr. Boardman or Ms. Burke. So under the current proposal, so under the current displaced workers bill, how many workers, like I'm trying to understand the difference of universe between workers covered under our current law and workers covered under this proposal, under this legislation. So what's the difference? So we have, as I said, we have 150,000 workers in our city who have filed for unemployment compensation. Not all of those are W-2 employees, as we know, but how many workers would be covered under this legislation? And what is the difference between that number of workers and who is covered under the current displaced worker law?
Devki, I can take a crack at this and then you should jump in. The current law has two sets of limitations.
Mhm.
The first is the employers are defined as contractors, which is not as clear as the definition that we provide here.
Okay.
Essentially, we say every employer that had an employee that opens back up. That's our definition. That's clear and unambiguous. There is no basis for someone saying, well, I'm not a contractor. So as an example, Mr. Allen, who worked in a restaurant, his restaurant is not a contractor.
Okay.
It is a standalone employer.
So does not to interrupt you, Mr. Boardman, but would this apply? So would this apply both to W-2 employees and contracted employees? Is that how it?
That's an interesting question. And I think as you look at the bill, there would be a differentiation between employees of the employer with respect to a specific location, and the definition of and contractor that comes in and does work at a specific employer. So in my interpretation of the current proposal, our proposal is that both employment settings would be covered. They would be different employers, but both settings would be covered, so that if a temporary workforce agency, for example, had work and started calling people back to that employer, employees of that employer would have the same rights as employees of the employer, where they are coming into the same location, punching the clock every single day.
Let me ask my question in a different way, Mr. Boardman. As I said, there are 150,000 workers who filed for some type of unemployment compensation. How many of those workers would be covered under our current Displaced Workers Act, and how many would be covered under this legislation?
It's very difficult for me to estimate what might or might not be covered under the current Displaced Workers Act, because the current Displaced Workers Act deals with a transition. It does not deal with retention by the current employer.
Okay.
The Displaced Workers Act, when it was drafted, and for those who want to remember some history, that was a local 25 bill as well. That anticipated that when, say, a contractor at the US Department of Labor who ran the cafeteria lost the contract and a new contractor came in, that triggered the Displaced Workers Act that is currently in code.
Okay.
So there was in essence the capturing of a successorship argument.
Okay.
But what happens in our bill, council member, is those situations are covered. We have a successorship provision.
Okay. Okay.
But what we hope eventually will happen is that all of the businesses, some are currently closed, some are operating, as you heard from both Nedra and Tracy, either closed or operating at very low capacity. Those are the same and continuing employers. So the contracting law that is currently on the books, which anticipates and deals with the transition when a contractor leaves, that is not directly applicable to the situation that we believe exists today. And certainly not with any of the clarity that the language we're proposing anticipates.
So are all the workers who are currently receiving unemployment compensation, would this bill apply to them?
if they're currently receiving unemployment compensation, one makes the assumption that they have
and they're not working. So let's say.
and they're not working.
Right. So this bill would apply to every worker who
Yes.
has lost employment due to COVID-19.
It would apply from, in our opinion, from the standpoint of being covered by the law.
Okay.
The actual implementation is triggered only when the job which they previously held comes back online and exists again.
Okay. Okay. And then I'm going to ask again about enforcement, because certainly there are great benefits to being represented by a union and having folks like yourself be able to not only to bargain collectively and being able to balance the power of management, but having smart people like yourself be able to represent those workers. But I am still trying to understand how all those workers we're talking about who don't have the benefit of a union representation would be able to get their job back through this bill. So you're saying that this bill would give a private right of action for that worker to sue? Like, how would Mr. Allen get his job? Would he have to go to court if he says to his employer, well, I see that you've brought back workers, I think I have seniority, I should get a job before somebody who has less seniority? How would and if the employer says, well, I decided not to give you that job, how would that worker enforce the law? Would they have to go to court, hire a lawyer and go to court?
The enforcement provision, and I'll read the first sentence or so of it. It just says an employer or employees may, on behalf of themselves and or on behalf of other employees similarly situated, bring an action in the Superior Court of the District of Columbia.
Okay.
And the district and the court may award certain things as provisions of the enforcement, back pay and those types of things. So the direct answer to your question is, could Mr. Allen or Tracy or Nedra pursue this in a court matter? Absolutely.
Okay.
And do we anticipate that there would be agencies such as some of the ones you've heard testify this morning, including Local 25, that would help them do that? I think that goes without saying.
Okay.
So we are encouraged when there are multiple opportunities for enforcement, and we think that this is a critical part of making sure that those who are inclined to do the wrong thing are encouraged to do the right thing if they believe there is a consequence.
So here's my question, Mr. Boardman. Having dealt with many workers who are just really struggling right now, they don't have many resources, and taking legal action could be very expensive or intimidating. So do you envision that these workers would all file suit individually, or are you foreseeing like a class action approach? I have to say I'm not a lawyer, so I'm out of my depth here, but or swimming out of my lane. But I just see that we have thousands of restaurants, right? Thousands of employees in the retail and restaurant industry have been impacted who work for smaller employers, and it might be very difficult for them to A, know what their rights are, and B, take personal action to get a remedy on this bill or on this law.
I agree with you. I'm not saying any of these things are an easy path to righteousness. What I am saying is the more ammunition you have to go after employers that are not doing the right thing, and let us assume that there's a good number of employers that are going to do the right thing and are going to bring people back. But for those that don't, if they are looking at the potential of saying, the Workers' Rights Center lawyers, who I'm sure you're aware of, do exactly this type of thing. So do I believe that it is a cumbersome process? Yes. Would I prefer instant justice with that raining down? Yes. As a practical matter, we have the courts, we have district enforcement. We think looking at both of those is the best way to address this. And we also believe that this exact bill, because of the nature of the environment that we are in, workers in our industry, I can speak to our industry, and that includes non-union hotels and restaurants and those venues that we don't represent. People will hear about this. This is exactly the type of thing that they are concerned about, which I know is why Nedra and Tracy and Mr. Allen are with us this morning. This is exactly what they're concerned about, and their hope is that you guys will pass this.
Mr. Boardman, I am over time. I do think that, we have two goals here, which is to make sure that we are able to recover and provide good paying jobs to our workers. And I do think many employers do want to do the right thing, but we need to make sure that the law is understandable and accessible to them and their workers. I'm over time, Mr. Chairman, so thank you for your indulgence again. I appreciate it.
Thank you, Councilmember Silverman. Mr. Boardman, when you first pitched the idea of this legislation to me, you cast the context of the pandemic and its devastating consequences on workers in the hotel or hospitality industry. The bill that we're looking at is broader than just the hospitality industry, and we talked about that earlier. My question here has to do with the issue of time. I believe the bill as currently drafted does not have a sunset. So it isn't limited to the pandemic. It would be forever lasting. It seems to me that what this legislation is doing, and I don't mean to suggest there's anything wrong with it, is the government stepping into the workplace with some regulations. The government does that all the time, so I don't mean anything negative there. But that we are on firmer ground if we cast this in the context of the pandemic. The pandemic has caused thousands, tens of thousands of people, particularly in the hospitality sector, but across the board, to have lost their jobs. Temporarily, we think, they were told that it was temporary. So as part of our emergency response to the pandemic, where we've prohibited evictions and prohibited foreclosures and done, expanded unemployment, relaxed the requirements there. We've done all these things. In that context, we as a government would be saying, hey, guess what? We're going to say in the workplace that anybody laid off has the first right to come back. I know I'm oversimplifying the characterization. But the bill isn't limited to that context. Why shouldn't it be?
Well, I would argue 2 points, and I'll argue the more specific one first. It is impossible today to determine what the impact of this pandemic is going to be, or the term of that impact. We have no idea sitting here today, and again, using the hospitality industry, but again, the same thing is applicable across the board. In the hospitality industry, it is conceivable that to get back to a new normal may take 3, 4, 5 years for the industry to recover. And I'm not making this up. You can go into the common literature that is around now, and you'll see that the industry is not anticipated to get truly back on its feet until sometime in 23, 24. That's the first point. So we don't know what the effect of the pandemic will be, nor do we know what the tail on this thing is. And so to limit it for a period of time from that context, I don't think it makes sense. We don't think it makes sense. The second point I would say to you is, I think we have all been around the financial restructuring of the American economy enough, and I'm not trying to go super macro here, but we have seen over and over again waves of reconfiguration based simply on finances. And there are enormous incentives for financial operatives to displace and disrupt workforces in order to achieve financial advantage. If you have somebody like Nedra, who has been at the Marriott Wardman for 27 years, why not just close the hotel, get rid of Nedra? She's got right now 4 years worth of vacation, family health care coverage, all of the things that are at her wage level. Why not get rid of her, hire somebody who won't have health care when they first start, will start at a lower wage? Why not do that? And I'd like to sit here and tell you that capitalism behaves in a much more humane manner, but that is what we deal with all of the time. Hedge funds, private equity, pools of money that come in and out of the marketplace in various industrial sectors that don't care about employment and don't care about the people who operate in those workplace settings. What they care about is cutting costs. And not to put too fine a point on it, I'm pretty sure that we're not going to be looking to the federal government anytime soon to provide any protection for workers. The protections that are going to exist are largely going to exist because of bills like this that you as local legislators initiate. And I know that's kind of a long-winded way of answering your question, Mr. Chairman, but I think both of those things are important to acknowledge. One, we don't know where COVID is going or what the fallout ultimately will be. And two, that there is a larger issue of protecting workers during periods of time when they will be laid off and furloughed simply to cut costs.
Well, let me phrase the question differently. Prior to the pandemic, was this ever an issue? Workers being furloughed?
Yes, as industries have been restructured because of the entrance of financial restructuring, this happens all the time. Now, in our setting, Mr. Chairman, we have some protections. We have protections during the life of a contract for successorship. Those protections require that as the successorship moves through, that the successor rehire or hire in all of the employees. But who knows where that goes once you leave the protective world of a local 25 contract or an SCIU contract or something like that. We are, as you have seen on a number of occasions, looking beyond the limited interests of our members, which we believe coincide with the interests of other people in the hospitality industry, and ask that you protect all workers from these types of economic storms, which, at least for our industry, we know are coming.
Well, you're speaking generally, except with regard to hotels where you're speaking specifically. And with hotels, you're speaking about change in ownership. But I'm trying to think in other sectors, I just can't think of instances where there have been furloughs. And when I say furloughs, I mean temporary reductions in force, like we're seeing, or layoffs like we're seeing, but it's all expected to be temporary until the businesses come back. I just haven't seen that elsewhere. And that's what I'm trying to get you to refresh my mind.
Well, Mr. Chairman, I think it is absolutely safe to say and verifiable that the largest impact in terms of effect on a sector of the economic fallout from this thing has been hospitality and service sector generally. But once you get past hotels and restaurants, retail is completely tanking. Building occupancy and the attendant services that go with that, cleaning services, engineering services, those types of things, those are affected as well. So while you will, while the District of Columbia's economy tends to be overwhelmingly service sector, those are exactly the sectors that have been affected during this COVID thing.
Well, I'm going to interrupt you, partly because I'm now over my time and I didn't think I would be. And Councilmember Silverman might cut me off. We've been seeing a change in the retail sector as customers go more increasingly online, and as just the whole nature of the structure of the retail sector has been changing. But that's a different characteristic than what we're talking about here, which is that 80% or 70% of the hotel business has shut down and will come back over some period of time. And similarly, a huge percentage of restaurants have shut down or curtailed business, but are expected to come back. A transition in the retail sector to online is different. I'm trying to think of other sectors.
Mr. Chairman,
I can't.
give you an example.
Okay.
I think like another sector would be our security sector. So we have many workers, especially, and security has become an increasingly important sector for us as a entry-level employment. So we have many museums, we have our convention center closed. Again, it's tied to the hospitality industry. These workers have been laid off, and it's uncertain when they'll come back. I think that's a good example of an industry sector. I do have a line of questions along with this, but.
Okay, but security, again, the example you're giving is tied to the pandemic. And remember, I was getting at normal times, and I just haven't seen, I can't think of, that's where I'm trying to probe here. I can't think of where there have been instances, or at least any significant instances of furloughs where a business, a company, or a sector was having to unemploy people with the expectation of bringing them back. Auto industry, yeah, but we don't have an auto industry here.
Mm-hmm.
And security, if it's a contract, they're already covered by the Displaced Workers Act. So, and the example you were giving, Councilmember Silverman, seemed to be more pandemic related.
Okay, I see your point, Mr. Chairman. Well, we did have a furlough of government employees due to the recently because we couldn't reach agreement on the budget, federal budget.
Yeah. Mr. Boardman, I almost called you council member. Did you have anything else? I'm out of time, and then I'll turn to Councilmember Silverman.
No, I'll allow you to pass it over. Or
Councilmember
I'm not
Silverman?
allowing you to do anything. You have control of the hearing.
Councilmember Silverman?
Yeah, Mr. Chairman, I just want to, I don't really have questions, but to wrap up, I think the way I think about this bill and the situation that we are in is to look to sort of what are the goals we hope to accomplish here. And I think the goals we hope to accomplish here are to be able to provide some protections for workers, like I think it was to one of the workers who testified, who has been in her job for a very long time. And we want her to be able to benefit from that seniority and be able to return to that job. And there might be economic incentives to either current employers or to change the ownership structure of the work environment so that they could cut costs by not bringing that worker back and bringing a much younger employee who costs a lot less money. And we don't, I think we don't want to see that happen. We want to, I think for me, the North Star here is we want to make sure that our workers have the opportunity to come back to their employment and there aren't, we don't create disincentives for those workers to return to their jobs. But I share your concern, I think, Mr. Chairman, just about how this bill would work. I think we can find a way to do it, but I think it will take some further refinement. Thank you, Mr. Chairman.
I'm going to let you have the last word. I want to thank all of the witnesses, and even though most of our questions were focused, I'm going to say targeted to Mr. Boardman. I want to thank all of the witnesses for testifying and also for hanging in here. It's all been helpful. As I said at the beginning, the record in this matter will be open for 2 weeks. It will close at 5 p.m. on November 18th. So if anybody wants to supplement their statements, they have 2 weeks to do so. I'm hopeful that we'll be able to take this up at our legislative meeting on December 1st, and which will involve a committee markup as well. So with that, again, thank you to everybody. The time is 10:48 in the morning.